like to start by acknowledging the Tasmanian Aboriginal people, the traditional custodians of the land which we gather today, and I pay my respects to elders past and present. I'd also like to extend that respect to any Aboriginal clients or people who are with us today. So I am Maria. I'm the Marketing and Business Development Manager at the Public Trustee, and we are joined by Naomi Fu, who is our solicitor at the Public Trustee based here in Hobart. And we also have Kate Glover, who is the Sector and Community Engagement Officer at Palliative Care. And we also have Isabel Shaddock, and she's helping us with the comments. I've just got a couple of housekeeping issues that we'll just cover. Today's webinar has been recorded. You may have just noticed that there's a little record button at the top. We'll share this link after the presentation, so please feel free to share this with your, colleagues or friends, whoever you think might be also interested in this topic. Because we are recording, if your video is on, you may possibly be in our presentation. So if you don't want that to happen, please just turn your video off and, you won't be seen. We also ask that people mute themselves just so that we don't have any feedback, and it just makes it easier for the presenters to speak and everybody to be able to hear. So that would be really great if you can do that for us as well. So the presentation should go for about 40 minutes. And we'll have some ability to answer some questions at the end. If you've got a question, please just pop it in the chat group, and we'll either ask the speaker as they're going, or we will save it to the end and we'll ask the questions at the end. So that might be the best thing. If you just put your hand up or just put something in the chat box, then we'll know that you've asked a question. Excellent. Well, I might just sort of go into my next slide, which is our disclaimer. Today is just general advice. We're not going into anyone's personal circumstances, so please make sure you get tailored advice to your situation, and don't sort of necessarily rely on what we're speaking about, because it is just general in nature. So we are going to be discussing estate planning and advanced care decisions that you need to think about. So today, or last week was Dying Today Day. It's a public health campaign run throughout the year, and usually the annual day is about the 8th of August, but it does go for the whole of the month. So this year's focus is on personalising final arrangements and building community. So one size doesn't fit all when it comes to end-of-life planning, and we're all individuals and different personalities with different wishes and desires. So it is really important to think about what you want and to make sure you document your wishes, because it can be one of the greatest gifts that you can give to your family and your loved ones when the time comes, to make sure that they know what is going on and they've got plans in place, because it can really help them with the process. If they've got plans in place, they know what's going to happen. So the time and energy you spent on making estate planning decisions today will help ease the burden for loved ones and give them peace of mind. Now, what we are discussing today can be, I guess, a bit challenging for some people. So please take care. We are talking about end-of-life decisions. So, feel free just to be kind to yourself and sort of take the time as you need it. All right, well, I'm going to pass you on to Naomi. She's going to talk about the importance of estate planning and also give you a bit of a background about the Public Trustee and what we do.
Thanks, Maria. As Maria's obviously alluded to, the importance of estate planning cannot be understated. It's obviously very important to have these conversations, and not only gives you peace of mind knowing that your loved ones are well aware of what your expectations and wishes are, and obviously have a plan to follow through. So obviously it gives your loved ones peace of mind during a difficult time. And let's be honest, the last thing you want is obviously for your loved ones to dispute over or fight over who gets to make certain decisions for you, and who gets to inherit the whole or part of your estate or your assets. So what we'll be doing today is obviously we'll be discussing legal documents you would need in terms of the management of your medical, financial, and or legal affairs, if and when you become unwell and cannot make decisions on your own. We'll also be discussing a legal document which would allow you to set out how you'd like your assets to be distributed after you've passed away. Now, as Maria sort of mentioned, we understand that having conversations about death we'll be talking about a topic that's generally avoided. So we hope to make this process of approaching your or considering your estate plan less daunting. We also hope that this session, may be a gentle nudge that so you may feel that you're ready to take action and secure your future for yourself and your loved ones. So obviously, the sooner you get these estate planning documents in place, the quicker you can obviously have the weight off your shoulders and also have peace of mind knowing that, that if and when there comes a time to revisit your estate plan, obviously, and if and when your circumstances change, the foundation or most of the work has already been done. Now, advanced care and estate planning provides obviously peace of mind knowing that if something were to happen to you, your loved ones, your life choices, as well as your estate plan will be looked after in the way that you would prefer. And, unfortunately, without an estate plan in place, obviously a court or a tribunal may need to appoint, someone else to make those decisions on your behalf. And, the good news is with this advanced care and estate planning, well, it isn't a daunting process, or it's a never-ending process. It's sort of like an insurance policy that only kicks in when you sort of need it. So just to give you, I guess, a rough outline of the documents that we'll be discussing today, we'll obviously discuss about the Advanced Care Directive. This document essentially allows you to document your wishes and preferences in relation to your healthcare for when there comes a time when you are unable to communicate those, wishes and preferences in relation to your healthcare yourself. We'll also be touching on a legal document called an enduring guardianship. This document essentially allows you to nominate or name a person or multiple persons to make personal and or medical decisions on your behalf if and when you are incapacitated. And then we'll be touching on another document called an enduring power of attorney. This document, on the other hand, allows you to nominate a person to, manage your financial and or legal affairs. And lastly, we'll be touching on a legal document called a will, which I'm sure most of you are aware of. A will essentially allows you to obviously set up how you'd like your assets or estate to be distributed after you've passed away. Now, just before I hand it over to Kate to discuss what advanced care directives are and the work that palliative care does, what I'd like to do is just to briefly discuss the role of the public trustee. So the public trustee is a government business enterprise that provides obviously vital services to the Tasmanian community. Were established in 1915. We public trustee provides a range of free, subsidized, and/or fee-based community services for Tasmanians, taking the form of wills, estate planning services, as well as trustee services to generations of Tasmanians. So obviously we provide and give trusted advice when you need to make your will. We also provide service to have enduring powers of attorney as well as enduring guardianship documents. We don't, however, offer the service to prepare advanced care directives. We do administer deceased estates when we have been appointed as the executor of a will, and under certain circumstances, the public trustee may take on the role of an executor of a will, say if a private executor decides to renounce their role to the public trustee. Public trustee also acts as a trustee for various types of trusts, including accident compensation awards or criminal injuries. The public trustee also manages funds that are under our control. And more recently, in the last 20 to 25 years, the public trustee have been supporting people who have impaired decision-making abilities, owing to an accident or illness, with the management of their financial and legal affairs. So if a person ever needs support and does not have family or friends who can support them in terms of their financial affairs, public trustee can be appointed as an administrator by the Tasmanian Civil and Administrative Tribunal. So that's pretty much what I'd like to discuss about the role of the public trustee. Kate, can you now explain what palliative care does and what an advanced care directive is and why do we need one?
Absolutely. I'll just take control of the screen. So good morning, everyone, and welcome to our Advanced Care Directive session. My name is Kate, and I'm here representing palliative care today. And thank you to the Public Trustee for organising this event. As we know, each August we acknowledge Dying to Know Day, which is an annual event held on August 8th, which is part of the public health campaign aimed at encouraging Australians to engage in conversations about death, dying and grief. Today, I'd like to acknowledge the original owners and custodians of this beautiful island of Lutruwita, Tasmania. Lutruwita is rich in cultural heritage, and the Palawa Pakana people have walked this country for thousands of years and continue to have a deep connection to the land today. At Palliative Care Tasmania, we acknowledge the Palawa people's deep connection to family and community and their enduring strength and compassion in caring for their dying, sick and grieving. Just also a note for today, the information provided is general in nature and please seek professional health advice for further information. At the end of the webinar, the public trustee will collate any questions and will contact you directly by email with any discussions if we need to further in regards to questions. So Palliative Care Tasmania is a peak body for palliative and end-of-life care. We work collaboratively with our members and sector to ensure that all Tasmanians have quality, equitable and compassionate access to the support they need. 75% of Australians have not had end-of-life discussions. Talking about death and dying is difficult for many of us, and yet we know if we engage in these conversations, especially if we are living with a life-limiting illness, then we can ensure our wishes are respected and have better healthcare outcomes. Our families have better grief and bereavement outcomes, less stress, worry, and we will avoid treatments that we will not want. We need to start breaking down these stigmas associated with talking about some of these difficult and awkward topics and create better death literate communities so we can care for one another through life, through death and grief. Now, to explore what matters most to you, we'll watch this short film from Advanced Care Planning Australia, Love is Not Enough. As you can see there, up to 50% of people don't have a chance to have those end-of-life discussions. So the benefits of planning ahead is that it ensures preferences are known and followed. It eases stress for family members. It helps healthcare professionals avoid unnecessary or unwanted treatment, and it improves grief outcomes for families. So what is advanced care planning? Advanced care planning involves planning for your future healthcare. It is voluntary and it's for anyone of any age, but it especially becomes more important for those that may be at risk of losing their decision-making ability, are older, have multiple diseases or illnesses, developing dementia, are approaching the end of life, or living alone. Advanced care planning should happen when you are well, before there is a sudden need for decisions to be made. Ideally, advanced care planning will result in your preferences being documented into a plan known as an advanced care directive. So what is an advanced care directive, an ACD? So making an advanced care directive allows you to set out or guide what health care treatment you wish to receive in the future if you lose the ability to make or communicate such preferences and decisions yourself. You can include in your advanced care directive information about your values, your preferences, what can guide a person making a decision about your healthcare, and specific treatments you refuse and in what circumstances. The ACD helps health practitioners and others understand what's important to you and what to choose for you. It's a legal written document. As discussed, you can give specific instructions about certain medical treatments you do or do not want, your values and preferences. The ACD, so the Advanced Care Directive, only comes into effect if you do not have decision-making ability or are unable to communicate your preferences. A completed Advanced Care Directive can be registered with the Tasmanian Civil and Administrative Tribunal, TASCAT, and an Advanced Care Directive must be written in English. The directive will only operate when the person has impaired decision-making ability in relation to a healthcare decision, and the direction consenting to or refusing healthcare is clear and unambiguous. Under the legislation, if someone has lost decision-making ability, they cannot complete the ACD. This image shows the TASCAT, the Tasmanian Civil and Administration Tribunal registration form for Advanced Care Directives, ACDs. The form is used to register an Advanced Care Directive with TASCAT. The TASCAP portal allows health practitioners to search for and access an individual's ACD. An ACD made in accordance with the Act can still be valid even if it's not registered with the TASCAP. So what do I do when I filled in my advanced care directive? You can keep your original advanced care directive at home. You can inform your family, guardian, health practitioner, local hospital, and others that you have completed an advanced care directive. You should provide your advanced care directive to paramedics during ambulance visits, and you can upload your ACD to your My Health record via MyGov, and also register it with the ACD with the Tasmanian Civil and Administration Tribunal, TASCAP. We have a dedicated website to help you further understand and fill in the form for the advanced care directives. This is a website here. It's in multiple languages as well. And remember, the goal isn't for everyone to for every patient to complete a legally binding ACD, but rather enable your patients who are elderly living with a life-limiting illness to have an early opportunity to learn about advanced care planning and consider their preferences. The most important thing are the conversations. Thank you.
Thanks so much for that, Kate. Naomi, maybe you'd like to now talk to us about wills, enduring powers of attorney, and enduring guardianships.
Yes. Apologies for a moment. I seem to have lost the slides on my end. Yep. Sorry. Thank you. All right. Apologies for that. So as previously mentioned, advanced care and estate planning is an important aspect of providing protection and support, not only for yourself, but also more important for your loved ones. In the event if something were to happen to you where you no longer have the ability to make healthcare, financial, and or legal decisions on your own. So to ensure that you have the right plan that meets your needs, as well as the specific needs of your loved ones, it is recommended that you obtain professional assistance to prepare or have these legal documents prepared for you. So what I'll do now is obviously I'll give you deeper understanding of each of these 3 estate planning documents, starting with the enduring power of attorney. So to give you some context as to the relevance and importance of having an enduring power of attorney document in place, you may first wish to, consider these questions. Who would you prefer and entrust to look after your monies in your bank accounts? Say if you suddenly had an accident or become unwell, do you have someone that you prefer not to have access to your financial monies in your bank accounts or make financial decisions on your behalf? Now, an enduring power of attorney document essentially allows you to nominate or name a trusted individual or multiple individuals, such as a spouse or a loved one, or an organization such as the public trustee. So we call this person your attorney. Your attorney essentially looks after your financial and or legal affairs during your lifetime, either when you instruct them to do so or when you no longer retain that decision-making capacity anymore. Now, without this document, the control of your financial and or legal affairs, well, they're not automatically assigned to your spouse or loved ones, and therefore, your loved ones may be left without the ability to operate your financial affairs. They may not be able to pay bills on your behalf, sell your property, or deal with your financial and or legal affairs however they see fit and appropriate. Now, an enduring power of attorney document needs to be registered with the Land Titles Office. So you may wish to get it registered in advance or until a need arises for your attorneys to look after your financial and or legal affairs. Now, until a need arises for your enduring power of attorney to take effect, you obviously will maintain independent financial control over your own affairs, at which point you can obviously have peace of mind knowing that in your time of need, your financial and or legal affairs are managed by persons you entrust to do so on your behalf. Now, unless you are declared bankrupt, an enduring power of attorney document only operates during your lifetime and automatically ceases once you passed away. Now, obviously, before you nominate or appoint anyone to act as your attorney, you should carefully think about who you entrust to obviously look after your financial affairs on your behalf. The role of an attorney is obviously quite a demanding job filled with wide-ranging responsibilities. It requires a good working knowledge of legal, business, financial, and or investment matters. And in some circumstances, it may be unreasonable to ask a friend or relative to take on this role, and as such, in those circumstances, it may be ideal to nominate an impartial or independent person or party to act on your behalf, such as the public trustee. Now, I've got a comment from Imran, so he's mentioned. So with the registration of the enduring power of attorney document, that registration process gets completed at the Land Titles Office. All right, so now moving on to another estate planning document, an enduring guardianship. So say if you suddenly become unwell or have been involved in an accident, you may not be able to obviously communicate your wishes and or preferences as to your healthcare and or lifestyle related affairs. This may, of course, include what sort of medical treatment you'd like to receive, whether you'd like to live in your own home or in a nursing facility, who can visit you, and what sort of personal services you would prefer to receive, such as home support, for example. Now, an enduring guardianship document essentially allows you to nominate or appoint an individual or multiple individuals to act together to make personal and or healthcare decisions on your behalf when you no longer retain the decision-making ability. Now, obviously, we call this person your guardian. You can, of course, nominate a sole guardian or multiple guardians to act on your behalf, as well as a substitute or backup guardian to make decisions on your behalf in circumstances where the original guardians are absent or incapacitated and is therefore unable to act for you. This document is obviously especially important if you have specific wishes about your healthcare and preferred persons you wish to name to make those medical and or personal decisions on your behalf. Now, when appointing a guardian, they must obviously be an adult. They must be over 18 years of age. They cannot be a person who is involved in an administrative or professional capacity in your medical care or treatment. Take, for example, your general practitioner. So obviously you can't nominate persons as such. You also cannot nominate the public guardian or public trustee to act as your enduring guardian. Now, your enduring guardian essentially should be someone you trust and who knows your wishes and preferences as to what sort of healthcare or medical treatment you'd like to receive. There should preferably be a person who is decisive and able to advocate on your behalf to medical staff, care providers, and or members of your family. Now, your enduring guardianship document must be registered to have legal effect. This registration process occurs at Service Task. Now, an enduring guardianship document only comes into effect if and when you've lost the decision-making ability. So hopefully, the hope is you never need that document. It may never become operational. However, if an unwanted medical emergency arises, you can have peace of mind knowing that you have appointed a person or multiple persons to advocate for you, your wishes that relate to your medical and or lifestyle preferences. All right, so that's the enduring guardianship document. Now, more importantly, I'm sure most of you would like to know what would happen, say, if you were to lose decision-making ability but have not appointed an attorney and or a guardian. So say if you were to lose your decision-making ability, you have not appointed an enduring guardian, decisions about your medical and or dental treatment may be made on your behalf by a person responsible. Now, what a person responsible is may differ depending on your personal circumstances. It may be your spouse or someone with whom you are in a close and continuing relationship with. Now, obviously, if no one springs to mind and no one falls within that definition, it then reverts to an unpaid carer who is providing support to you. And say if you do not have a carer at that point in time, that person responsible would be a close relative or a friend who has a close personal relationship with you through either frequent personal contact and who has a personal interest in your welfare. Now, this could, of course, include a child or even your next door neighbor. So as you can probably appreciate, this person responsible default system may in some circumstances not reflect your preferences as to who you would like or prefer to make medical decisions on your behalf. Now, in circumstances where a person responsible does not wish to make or consent to medical treatment on your behalf, the Tasmanian Civil and Administrative Tribunal may be called upon to make a determination. Now, the tribunal may then, appoint the Office of the Public Guardian to make medical and/or personal decisions, medical decisions on your behalf. So that's in the context of, medical decisions. Now, say if you do not have an appointed attorney, and for example, if, your loved ones need to access your bank accounts to manage your financial affairs for you, or in the worst case scenario, say should there be a dispute as to who should have access to your bank accounts or who should look after your financial and or legal affairs on your behalf. Likewise, the Tasmanian Civil and Administrative Tribunal may be called upon to help at that point in time. So they'll hold a hearing, and in most cases, they will appoint a family member or a friend to assist. Now, say if there is no one to help or no one suitable that the tribunal thinks who should look after your financial affairs, the public trustee may then be appointed to support persons who obviously do not have an appointed attorney. So as you can probably appreciate, in some cases, both the public trustee and the Office of the Public Guardian may be appointed to support a person with the management of their financial and or legal affairs, as well as their personal and or medical related affairs. So that's the enduring power of attorney and enduring guardianship documents covered. What I'd now like to do is just essentially to talk about a will. So obviously, when you pass away, your will pretty much specifies how you'd like your assets and or property to be distributed. Your will's pretty much your voice after you've passed away. Now, obviously, with a will, you can set up your expectations as to how you'd like your assets to be distributed and who you would like to inherit your assets. Your loved ones obviously will be provided for and be able to grieve in as healthy a way possible without hopefully any fights amongst family members or loved ones as to who should inherit your assets. Now, as part of your will, you would need to nominate a trustworthy individual or multiple individuals or even an independent organization to be responsible for carrying out your wishes in your will, such as the sale of your property and the actual distribution of your assets. So we call this person your executor. Now, the importance of having a professionally written and up-to-date will cannot be understated. To name a few reasons as to why it's important to have a will, it of course ensures that the right persons are provided for when you pass away. It enables your assets to be distributed according to your own wishes and preferences. It minimizes disagreements amongst those who expect to benefit from your estate. It also assists those who are responsible for managing your estate to understand how you would like or prefer to have your estate to be managed. And obviously, it enables your estate to be administered as efficiently as possible. Now, even if you do not think you have many assets, it's probably advisable to still have a will and documented plans in regards to how you'd like your assets to be distributed, especially in circumstances where you've got assets of sentimental value that you'd like to leave to specific family members or specific persons. Take for example, if you have pets, obviously you may wish to consider who you'd like to leave the care of those pets to. So obviously, the importance of having a will and keeping it up to date cannot be understated. So we obviously strongly recommend that you seek professional advice when you have your estate planning documents, your will, enduring power of attorney, as well as enduring guardianship documents prepared. You may wish to have these documents prepared with a solicitor, or you could also have them prepared with the public trustee. Now, I'm sure everyone has probably heard of, do-it-yourself wills or will kits. While it may seem that it may be convenient to write your own will from Doing so may be problematic, and what's worse is obviously when you go and write your will, issues regarding the validity of your will may only present themselves after the person who has wrote the will has passed away. So to paint a picture, say if a will is not prepared correctly, it may end up costing more to rectify any issues that relate to the validity of the will or the actual administration of the estate, which in effect may create an even bigger emotional toll on your loved ones. Now, if you do decide to have your estate planning documents prepared with the public trustee, your will document prepared with the public trustee, you have the option or choice of appointing a family member or friend to take on the role of an executor, so to manage your distribute your assets. Now, if you do not want to burden your family or want someone impartial to deal with the administration of your estate, you also do have the option of appointing the public trustee as your executor. Now, so say if a person passes away without a will, that person's essentially passing or die intestate. So at that point in time, the intestacy laws would then determine how that person's estate is distributed. This may, of course, mean that the estate may not be distributed according to the deceased person's wishes. At that point in time as well, an application needs to be made to a court to seek an order to appoint an administrator of the estate. So in Tasmania, the distribution, it's made according to a formula laid out in the Intestacy Act 2010. So essentially that formula sets out who obtains priority in terms of the actual inheritance of and assets of a person who has passed away intestate. So as you can probably imagine, a distribution determined in that way may create significant problems. So for instance, the assets or estate may pass to a relative who had little or nothing to do with the deceased person. Obviously, this is why dying without a will can be problematic, as your estates may not be distributed to loved ones who are probably closest and most important to you. It can also cause delay and additional expense if those left behind, argue as to who should be appointed to act as the administrator of the estate and whether or not the intestate distribution actually adequately provides for those people who are closest to the deceased person. So that's pretty much all I want to say about a will. So probably hand it back to Maria.
Thank you so much, Naomi, and thank you also to Kate. That's a lot of information that we've covered today.